For pronouncement of judgment and order, item 1.
In view of the above, the reference made by the learned single judge is answered as follows. Then the anticipatory bail application preferred by a juvenile under section 438 of the CRPC or under section 482 of the BNSS is maintained. Accordingly, the response is disposed of and the registry is directed to list the anticipatory bail application before the appropriate bench after the.
Adjournment request, if any, from item number 1 to 6. From 8 to 17. 18 to 28.
With regard to item number 16, your lordship, I have filed one affidavit today.
1/6.
Yes, your lordship. May I be allowed to bring it on record? Affidavit for dusty report.
Call for the.
Master.
18 to 28.
May I please, your lordship, I beg to mention item number 28. Lordship, my senior is out of station. Kindly adjourn the matter for a day.
Madam, this is the order. You have to take steps. Some will pass an order, let the number come.
I love it.
29 to 36.
May I please, your lordship, I beg to mention item number 32 and 33, your lordship.
33 and 34.
No, your lord, 32 and 33, your lordship.
32 and 33. Yeah.
Lordship, consent has been taken, your lordship. Lordship, my senior is unwell today. Matter may be adjourned.
42 and 43.
32 and 33, your lordship.
Yes.
May I please, your lordship? I beg to mention item number 31. And for the appellant lordship, my senior, Mr. S. Gotago is under treatment. So my pay for after 2 weeks.
Under treatment.
Treatment lordship.
Treatment. Adjourn.
31. Highly blessed.
Yes.
37 to 45.
Maybe, your lordship, I beg to mention item number 38, my lord.
Item number
38, my lord. 38, my lord. Do we have some difficulty, my lord?
Yeah.
Came up after truth, my lord.
Have you informed the other side?
Yes, lordship.
Adjourn.
Our lordship.
Yes.
46 to 50.
42. May I please, your lordships? With
Yeah.
consent from the other side, I beg to mention item number 42.
It's a hearing matter, man.
Lordship,
Hearing
senior
it.
counsel, Mr. G.N. Saiwala is unwell. Is why I have to seek an adjournment.
It will be remained on the board.
Password.
Password.
Obliged.
May I please, your lordship, I beg to mention item number 45.
Yeah.
My senior SK Vidhi, CDC counsel, he is out of station today. The adjourn to
It
the.
will remain on the board. Password for the day.
My lord, I am for the opposite side, my lord. We have no objection, my lord.
You have objection?
No, I don't have any objection.
Okay, then
It may
Okay.
kindly be adjourned for the day.
not adjourn. It will remain on the board.
Pass over for the day.
Passed over for the day, it will remain on the board.
Highly obliged, my lord.
Obliged.
Yeah, please, your lordship. My lord, I beg to mention item number 47, my lord, 15, lordship. Lordship, in these matters, my lord, some instruction are still awaited, my lord. My lord, may I pray, my lord, matter may be passed over for at least 3 weeks, lordship.
47 to 50.
50, lordship.
What instructions you need now?
Lordship,
What instructions you have?
Lordship, a similar matter has been disposed of by the Delhi High Court, Lordship. And my lord, we have sought for instruction whether any further appeal has been preferred before the my lord Honorable Apex Court, my lord, and a letter has been written to the my lord
The Delhi High Court has decided in favor of the revenue,
against the revenue, my lord,
against the revenue.
Lordship. So, my lord,
May I please, your lordship? Your honors, the Delhi High Court subsequent year in the order rendered on 16/7/2024 has again decided the issue in favor of the assessee, dismissed the revenues appeal, and the standing counsel in the Delhi High Court has admitted this order has attained finality. I would like to place that judgment, let it come in this.
my lord, we have written letter to the my lord,
Okay, after a week, it's it, to get it confirmed,
Lordship.
and you also supply him a copy of that Delhi High Court latest judgment, which you are referring to.
Lordship, specific instruction has been, my lord, sought for as to whether the department has accepted the, my lord, decision of the Delhi High
Matters, whether
Lord.
the department accepts it or not accepted.
Lordship.
We have to decide the matter,
Lordship.
not depend upon your acceptance.
Lordship. No, my lord, only whether further appeal has been preferred or not.
After a week only, not more than that.
Lordship, deeply
After
obliged.
a week.
Your honors, can you allot us a fixed date for hearing?
Ask the court martial, he'll give you the fix.
Obliged.
Deeply obliged.
May I please, your lordship? I beg to mention item number 46. It may be listed after a week.
Yeah,
Sir,
what do you want?
or adjournment, sir. No,
Why? It's a hearing matter.
senior has not yet.
Who's your senior?
Bibu Caster.
Where is he?
He is in court number 26.
So he'll come when the number come. He's not supposed to be remain stuck in court number and for whole day. Call your senior. We'll see to it, number on.
Obliged.
For orders, item number 1. 1 and 2.
No fresh steps.
Lordship allows further time to take fresh steps, Lordship. Earlier, we took steps, Lordship.
We have already granted you earlier time. A week's time is granted. Further time is granted to take steps for service of notice upon the respondent number 1, 2, and 3. As per the direction given by this court on 29/5/2024. Mr. President.
Deeply obliged.
Item number 3 and 4.
My lord, in these appeals, on the last occasion, I paid for time for substituting respondent number 1 in the first case, who has expired in the meantime. And today they have supplied the names of the legal heirs. I'll file the substitute petition within 10 days time.
Yeah, 10 days time is granted to file the IA for substituting the legal heirs of the respondent number 1.
Deeply.
Item number 5 to 7.
Yes.
Well, we have taken fresh test, my lord, pursuant to the last order, my lord.
From council has submitted that pursuant to the order passed by this court on 15/5/2024. Steps have been taken
On 24/5, my lord.
on 24/5,
24/5 to 2024.
24/5/2024. Trustees will check. And if the steps have been taken, let notice will be issued to the answered respondent returnable 6 weeks.
Oblige, lordship.
Item 8 to 11.
Lordship, we have filed a reply today morning. To the affidavit in opposition filed by the BSNL lordship.
I did, my lord.
You are for,
We are for the contempt petition of lordship.
that is all the record. Today,
Today morning we have filed,
you have filed some another affidavit.
lordship. On the last occasion, the BSNL filed the affidavit in opposition. To that opposition, we have filed a reply, lordship. On the affidavit. Matter may come up on Friday, lordship. Till then,
After a week,
I will oblige for it.
Item 12.
My lord, in this case, my lord, the appellant has already got the release, my lord.
yeah, you are for the appellant.
Yes, my lord.
So it has become infectious.
Yes, my lord.
And concept of the appellant has submitted this writ appeal, becoming just dismissed as infectious.
Oblige.
Item 13.
I yes, I is also dismissed. B is well.
The states were to produce their relevant instructions.
Well, the from the deputy commissioner, I have received some instruction, my lord. Well, out of the 2 circles, my lord, in some of the villages they have done.
But in this case, the positive directions were there for 2 authorities. Because we had filed a case that before notification of the wetland rules, they were trying to change the character. The Mr. Nath was directed to file an affidavit giving the coordinates. And Mr. Nayak was directed to file as regards the whether land filling is going. Well, our anxiety is that for the past 2 years, judicial directions of this court that they will be notifying the eco-sensitive zone were being postponed. So the entire bill is under threat. And in the meantime, they wanted to denotify it. It is because of your lordship's intervention that the bill is protected now. So I pray that at least the affidavit, because they are taking it, because lordship, I can read the orders. There are 5 orders of this court from 2023 onwards.
Mr. Nath, they are repeatedly saying that despite interim orders of the court, some earth filling work is going on in the Dipperville area. That's their repeated contention. The court has passed an order not to tinker with the Dipperville area physically and not to even do it legally, right? You are saying there is no earth filling going on. When anyone goes to the airport, one can see the earth filling work going on in it. You are not clarifying, you are not coming clean. What is this?
Not to that effect, my lord, an affidavit is being filed by my learned friend for the GMD, my lord.
Yes.
They are filing it, my lord. For the PWD, they are filing it.
No,
For the-
in the affidavit, you say no earth filling. They are saying
there-
earth filling and we can see the earth filling going
No,
on.
They are ultimately, possibly in their affidavit, they have said that there is some earth filling, but What is the actual position in their affidavit? They have disclosed, right?
But how can there be some art filling if there is a stay order from the court?
Well, that inspection.
Is it being done in violation of the court's order?
Absolutely.
The GMDA has the authority, they have filed the affidavit, they will explain. They will explain.
Then you sit down, yes, you explain it.
Lordship, so far as my instruction from GMD authority is concerned, Lordship, to that effect, today we are filing one affidavit also, Lordship. Today itself we are filing.
What
But
about the art filling?
yes, art filling, some work are going on by the PWD department. But when clarification was sought for Lordship, the PWD said the executive engineer PWD issued a letter by number so and so, along with clearance from the State Environment Impact Assessment Authority, Lordship. So whatever they are doing,
What work is going on?
Lordship, up to the airport, Lordship, one loop is, construction of a loop is going on, Lordship, elevated loop. And they are saying that once the loop is constructed, the entire art that has been deposited there, that will be removed. That is the understanding, Lord.
Mr. Das, there is an order not to carry out art filling.
No, that was not, they wanted, Lordship wanted their response. Mullah, I pray that that order be passed. Because what has happened, they are not giving the coordinates and they are art filling it, going for art filling. In fact, I'll take your Lordship to two orders of this.
From the PWD today
From GMD authority, today itself, Lordship, we are filing.
and explaining this, that.
Yes, Lordship, that has been explained.
Under what condition this art filling is going on?
Yes, Lord.
Okay, and you, Mr.
For the demarcation part, my lord, I have placed the instruction for the deputy commissioner, my lord.
They are here and nothing here and there.
No, my lord, they have already, I'm reading it, my lord. The high flood levels as provided by the NESSC of Dipperville falls under Guwahati Revenue Circle and Adara Revenue Circle. Under Guwahati Revenue Circle, the HFL is spread across 6 villages, namely Poschim Jalukbari, Dokhin Jalukbari, Tetelia, Poschim Boragao, Mas Jalukbari, and Uttar Jalukbari. The demarcation survey of HFL has been completed for Poschim Jalukbari, Dokhin Jalukbari, Tetelia, and Poschim Boragao. The survey could not be completed due to inundation of area in Mas Jalukbari and Uttar Jalukbari. The survey in these villages shall be completed within 7 days of water level receding in the area. The water level is high at present, and due to monsoon season, it is difficult to commit the timeline on reduction in water levels. Under Jalukbari circle, the depot bill is distributed across 5 villages, namely Azara, Dharapur, Mikirpara, Chakradubi, Kahikusi, and Pamohi. Demarcation of HFL has been done in all 5 villages. However, report has been finalized for Azara and Dharapur. The remaining 3 reports will be ready in 10-15 days, my lord. This instruction has been given by the deputy commissioner.
5 days have already gone.
Yes, my lord.
10 days remain.
They said that within 10-15 days that the entire will be, they will give us the report.
We will fix this
Logic.
after 10 days.
Logic.
On that date, you file the affidavit along with the report for these 5 villages.
Logic.
Okay.
Sure.
Mr. Nath has submitted that. High flood levels. Submitted the survey to demarcate the high flood levels in the Lipor Bay in respect of 6 villages has already been completed. However, the report in respect of all of the villages has not been finalized. They submitted that the same would be finalized within 10 to 15 days. So there's some time to file an affidavit
18 visualization date.
on this aspect. Full stop. Mr. Nath is granted time to file an affidavit along with the report regarding the high flood levels in the Lipor Bay area in relation to 6 villages by 12th of August 2024. So, Mr. P. Nayak, council appearing for the GMDC and PWD. GMDA and PWD. GMDA and PWD is directed to file a specific affidavit that whether any earth filling is going on in the Deportville area, and if it is going on, then necessary permissions from the respective departments have been obtained or not. Mr. Nayak may also file on behalf of the responsible officer by the next date of hearing, list on 12th of August.
Item 14.
Next one.
Respondent number 1,
But the respondent number 1 has appeared, sir.
you are appearing.
Yes, my lord.
Service is complete.
Service is complete, my lord. But there is delay of 171 days, my lord.
That is
Completion of development.
I am praying for my lord submitting one my lord reply in this case, objection.
objection.
My lord, because here, my lord,
We have already admitted, sir.
because here in this case, my lord, their ground is not at all, my lord, tenable.
But we have already admitted the similar appeals.
My lord.
The matter comes upon for consideration of the IA number so and so. With the prayer to delay the condonation. With the prayer to condone the delay of 171 days in filing the connected appeal. So now they submitted that in identical. Yeah, that against the impugned judgment, this court has admitted several writ appeals while condoning the delay. Full stop. When a counsel appearing for the respondent number 1 has opposed the application for condonation of delay, taking into consideration the fact that identical appeals, various appeals against the impugned judgment has already been admitted, we deem it appropriate to condone the delay. in filing the connected date appeal, hence IA number so and so is allowed, delay of 171 days is condoned. Registry is directed to list the connected writ appeal, to register the connected appeal and list this before this court after 2 weeks.
Item 15,
Obliged. Wait, please.
Yes, notices of respondent number 25, 26, 12 to 24, 27 to 30, 33 and 40 has not been received.
My lord, may I pray the matter be placed before the Lawazima court, my lord? We'll sort out this service and we'll take fresh steps upon which.
As per the office report, service upon various respondents have not been affected. So the matter is placed before the Lauzima court to issue necessary directions for service of notice upon the unserved respondents. The Lauzima court after a week.
No better than to 11. Huh? 7 to 11 weeks.
item 16,
Respondent number 3 has not been served.
We served the dusty report on 26th or also the affidavit is not the common record. This is the extra copy I have, your lordship. That's page number 92. They received the copy, your lordship.
So this is affected.
Yes, yes. Yes. That's page 92, your lordship.
Anybody is appearing? You are appearing for
1 and 4, Lordship.
1 and 4.
Lordship.
Nobody is appearing on behalf of respondent number 3.
Not yet, your lordship. We'll start from 26, your lordship.
Yeah. Let me consider that. The petitioner has submitted that he has filed an affidavit stating that the notice upon the respondent number 3 has been duly served. Stop. The registry is directed to place the said affidavit on record and also to check whether anybody is appearing on behalf of the respondent number 3 and not list after 10 days.
item 17,
Well, the office report reveals that neither ready nor answered notice has come back. Not
I mean,
like you can wait for 10 minutes or keep.
await return of notice of sole respondent for 3 more weeks.
Available.
item 18,
Respondent number. AD card in respect of respondent number 8 received, accepting notice received. Respondent number 1 to 7 received, yes. All the respondents are served.
Yes, Lordship.
You have filed the writ petition challenging?
Lordship, imping on the Lordship, so far as my concern, Lordship. So here, Lordship, my brother has filed this case, Lordship. Some, actually, sorry for that in this regard, Lordship. So basically, Lordship, the matter pertaining, Lordship, the misappropriate the midday meal, Lordship. So initially, I was promoted as a headmaster, Lordship, in charge headmaster, Lordship. So subsequently, Lordship, they have reverted my post, Lordship, as a headmaster of that particular school, Lordship. So only reason behind, Lordship, is a false allegation imposed, Lordship. So I have immediately filed a reply petition page 38, Lordship. So I was did not misappropriate any kind of the midday meal of the school, Lordship. And page 81, Lordship. And the DP has not been finalized, Lordship, as on that, Lordship. If it possible. And page 38, my reply, Lordship. Focus notice imposed by the BO, Lordship. The Block Elementary Education Officer, Lordship.
You have to leave.
So you have filed the writ petition challenging the suspension order.
No, Lordship. It's a
Suspension order, this copy of the writ is you have next writ petition number 6853.
is a yes, Lordship. I have challenged the
Suspension order.
single just order, Lordship.
Oh, that's in the writ appeal before the learned single judge, you have challenged the suspension order.
Yes, Lordship. Lordship,
And that suspension has already been revoked.
yes, Lordship.
Now what remains?
Lordship, whatever, so here in this case, Lordship, so the DP has not been completed, Lordship.
DP has already been completed, punishment has been awarded.
No, DP has not been completed, Lordship. The page
Sir,
81, Lordship.
Here, learned single judge has observed this, sir.
Page 81, Lordship.
Sir, not 81, please, read para number this first page.
Of the imping order, Lordship.
As per the last order, submission of the council was recorded that the petitioner has reinstated in his original place of posting with stoppage of one increment with cumulative effect, provided that the next senior most teacher is allowed to act as in charge of in place of the petitioner. Today, when the matter was called up, Mr. Datta, counsel for the petitioner, submitted pursuant to the order dated 24/1/24, stated to have been passed by the director, a copy of the said. The petitioner has also been allowed to join in his original place of posting. So what remains then?
Lordship, so far as my concern, Lordship, so the initially, Lordship, the page 34, Lordship.
Yeah.
Page 34 in my petition.
Yes.
Lordship, here, Lordship, may I read, Lordship?
Read.
As per the proposal of the Block Elementary Education Officer, Rupohi, height letter nong so dated so the Mobaruk Hussain, this is a appeal and Lordship, at the Puthikaiti ME School, under B or Ubohi is hereby allowed to hold the charge of the headmaster of the school temporary in the addition to his own duty as assistant teacher with the authority to rule the disburse so the related so effect so. So he was in charge of the headmaster lordship with effect from 1/10/2020 to 31/12/2020 lordship. Till the joining of the regular headmaster and headmistress, whichever is earlier hired so headmaster retired so lordship. So lordship, I was promoted as a headmaster lordship. So subsequently lordship, so due to the false allegation lordship, I was rewarded my post lordship as a headmaster lordship. So lordship, my post is no doubt a reinstated lordship, but as a headmaster, my grievance is as a headmaster lordship.
Okay, come to this page number, appeal ka page number 27.
Yes.
Read the prayer part,
Yes, lordship.
para 21.
Yes, lordship.
Yeah, read.
In the premises, therefore, it is therefore prayed that the lordship would be pleased to admit this writ appeal, call for the records, issue rule calling upon the respondent to show cause as to why the writ in the nature of the mandamus certiorari or any other writs, order or direction shall not be issued, directing the commanding the respondent authority to reinstate the petitioner in his service, so that headmaster lordship, I admit lordship, I'm sorry for that lordship. My brother has filed this case lordship, but whatever lordship. So my post, no doubt.
Just a minute, just a minute.
Yes, lordship.
So your prayer was for setting aside the suspension order. This was the only prayer.
Invoking the issue suspension order so. Right, annexure number 9 issued and director of the. Yes, lordship. Yes.
That is at page 72. The suspension order.
Yes, lordship.
So you have challenged the suspension order in the writ petition.
72. Yes, lordship.
That suspension order has already been revoked.
Yes, yes. I'm sorry for that, lordship.
Then what remains in this petition, in this appeal?
Withdraw, lordship.
Notice upon all the respondents as duly been served. This writ appeal is filed by the appellant against the order dated 4/3/2024, passed by the learned single judge in writ petition number 6853/2023. Stop. In writ petition number 6853/2023, the petitioner has challenged the suspension order dated 16.
16/6/2000. Lordship, I appeal.
16.
Lordship, I'm sorry for that, lordship.
16/6/2023, issued by the Director Elementary Education, suspending the petitioner from the post of headmaster
I think that's it will be lost by the.
ME school under the BEEO Gupahi. Full stop. Learned single judge has noticed that in the departmental proceedings, the petitioner has been awarded some punishment, and thereafter a suspension order has been revoked, and he is allowed to join on the original place of posting. While observing this, the learned single judge has disposed of the writ petition with the direction to the in charge headmaster to permit the petitioner to join in his original place of posting. Having heard the learned concept for the appellant, and after going through the material available on record, particularly taking into consideration the fact that the petitioner has filed the writ petition challenging the suspension order, and when the same has already been revoked, no further order is required to be passed. Hence, we don't find any merit in this appeal, the same is therefore dismissed.
That's all right.
Item 19.
On the last occasion, your lordships had issued notice and they had prayed for some time to file their response, but nothing has been filed so far.
But for the state respondent, I have received some instructions. I prefer further 10 days time. I'll bring it on record. Good.
How much time?
I prefer 2 weeks time.
You are for?
I have for the respondent number. I mean, please,
1, 2, 4, 5,
1, 2, 4, 5,
8.
6 also, no? 6 and 8. No, 8 I'm not appearing. 1, 2, 1, 2, 3, 4,
But
5,
Dean,
and 6.
Appearing on behalf of so and so, so and so. Place some more time to file counter to the writ petition. It's writ appeal. Though earlier also enough time was granted, but in the interest of justice, last opportunity is granted.
No.
So Mr. Dean, have to file counter to the writ petition on behalf of the respective respondents, list on 2 weeks for admission. List on so and so for admission.
Like
16. 16. Item 20 and 21.
May
No
please, your
fresh
lordship.
steps for respondent number 3 and 5.
Yes, lordship. We'll take steps on 3 and 5, your lordship.
You are not, you are appearing for one?
I am for respondent petition, sorry, item number 21, lordship. I am appealing, lordship. Invite us to discuss, lordship.
Consent appearing for the petition, appellant, please. Some time to take fresh steps for furnishing requisite for service of notice upon the respondent number 3 and 5. Time period for is granted. A 1 week time is granted. On taking such steps, let notices be issued to the respondent number 3 and 5 through registered AD.
Oblige, your lordship.
22 and 23.
May it please, your lordship.
Respondent number 4 and 5
Yes, my lord,
have not been served.
yes.
Okay, await return of notices of the respondent number 4 and 5 for two more weeks. Yeah, 4 more weeks.
Item 24.
One to 4 has not been served.
My lord,
We'll await return of notices of 1 to 4 for 4 more weeks.
my lord, in Lozima court, my lord, it may be listed. Oblige.
25.
May I please, your lordship. My lord, the order is at page 16, my lord.
16.
16, 1, 6.
Does that.
And operative part, my lord, at page 18.
Have you filed that representation?
Yes, my lord, that is page 19. Page 19 is the, my lord, 6/11/2020.
Which is the department?
Yes, my lord.
Which department it is?
My lord, it is, my lord, electricity, Assam State Electricity Board.
Who is appearing for the ACB?
First is TV.
ACB.
Hello, Chayan, and I Perhaps the names have not been reflected.
Oh, not reflected, but since the direction is only for the deciding the representation, what happened to that representation?
No, we will not even receive a copy, my lord. I do not have the.
Supply and copy. Mr. So and so. Standing counsel. You are standing counsel?
Yes, my lord.
Standing counsel for the AP.
DCL, my lord.
PDCL. PDCL is directed to submit a factual report stating that whether the representation filed by the petitioner pursuant to the direction given by this court on 18/10/2023 in PIL number 67/2023 has been disposed of within the stipulated time or not. Copy of the contempt petition is supplied to Mr. So and so during the course of the day, just after a week.
My lord. I'm deeply aware.
Oblige me. I'll show you.
26,
Please, my lord. Where the application is for condonation of delay of 610 days, my lord. Initially, lordships were not convinced with the explanation given. We have given an additional affidavit where we have given all the departmental communications and the steps taken. They have filed an affidavit in opposition to the same model. Here,
You have filed this additional affidavit when?
this additional affidavit was filed on 25/6/2024, madam.
Where to take one? 6, 7.
Mr. Chaudhary, the central issue here emerging from the order, it has got some link with the special bench matters which are being heard. Where the provincialization is also an issue.
What has happened here is the repetitioners had prayed, specific prayer was made that they should be allowed, they should be considered, or they should be provincialized under the 2017 Act. The learned single judge went ahead to say that it will not be under the 2017 Act, it will be under some, under one of the cabinet decisions. No matter that cabinet decision, when we had followed the cabinet decision, we had proceeded to provincialize them under the 2017 Act. It was kept on hold because there was some issue regarding their UDAS. The entire challenge in the repetition was that UDAS cannot be a criteria to reject us for provincialization. Allow the provincialization under the 2017 Act. Learned single just rejected that part and said that no, it has to be done as per the cabinet memorandum from 2016 onwards.
So they have already
That's the only
been,
reason.
they have been already
No,
provincialized.
they were not provincialized because their UDAS was not matching. So their prayer in the repetition was that provincialize us, ignoring the UDAS part, as has been done for other candidates who were provincialized under the 2017 Act, who had the UDAS. That was the prayer. But the learned single judge, if Lordship will have page 181, said that 2017 will not be applicable, do it from prior to that. But that becomes a difficulty for us. If it is under 2017 Act minus the UDAS, it would have been a different chapter. We would not have been in an appeal perhaps. So whether the UDAS is necessary or not was to be decided. If Lordship will have the prayer at page 64 of the repetition.
But the appeal has not been served on us, so we are totally unaware of.
A repetition of the prayer I will read and the order of the learned single judge is only what I will read. No other grounds I will make up to place before Lordships. Page 64, anyway, 35 of the repetition, page 64 of the writ appeals. A writ in the nature of certiorari should not be issued, setting aside quashing the impugned order dated 2010-2020, whereby the respondents have denied the petitioners the benefit of being appointed as teachers under the provisions of Assam Education Provincialization of Service of Teachers and Reorganizations Act 2017. Reading the mandamus in the nature of mandamus should not be issued, directing the respondents to forfeit regular services of the petitioners and subsequently appoint the petitioners as teachers or tutors under the provision of the Assam Education Provincialized Services Act 2017. C. Read in the nature of mandamus should not be issued, directing the respondents to forfeit regularize the service of the petitioners and subsequently appoint the petitioners as teachers, tutors under the provisions of Assam Education Provincialized Services Act 2017. With effect from May 2017 was the specific prayer. Now, Lordship will find at page 121 what the learned single justice order matter. Page 181 at para 11.
With the cabinet decision which is made in the, before the enactment of the Act 2017.
Yes. So what we would say, what our stand is, under the 17 Act, let us
Yes,
consider.
But otherwise, my lord, normally I don't object on grounds of when applications are filed for condonation. But here is the case, my lord. If your lordships will kindly have the IA, in the cause title, The number of days delay mentioned is 610. Prayer mentions it as 670. And our calculation shows that it is 824 days. That is number one. Number two, your lordships had specifically noticed that the IA does not disclose any explanation, any reasons. Now they file an additional affidavit. Your lordship will, I have tried with my limited understanding, I have tried my best to find any explanation whatsoever. There's no explanation. In identical circumstances, by the same education department, there was a application for condonation of delay filed. The division bench of this court had allowed. The matter went up to Supreme Court and it was rejected. May I just simply place those orders? And the point raised was identical.
Division bench has allowed the application condonation of delay.
And that was reversed by the Supreme Court. And the point raised was exactly the same, that the 2017 Act will have. In fact, now order get a quote. If your lordships peruse the contention. No, your lordship will firstly peruse.
Just a minute, just a minute. Yes.
Your lordships will kindly peruse the division bench order dated 5/12/22, and your lordships will find a similar stand was taken on merits. This is an order passed in IA number 1447 of 2022. The fourth paragraph there will reveal that a similar stand was taken on merits.
Where is that?
There's a paragraph starting further. Further, it has been. Amalas got it.
Yeah.
Further, it has been also submitted that the state is in a peculiar situation inasmuch as the direction issued by this court was to regularize the service of the petitioner in terms of the Assam Venture Education Institutions Act, so-and-so Act 2011. The said statute, which was set aside subsequently by this court on 23/9/2016. Under such circumstances, though there may have been some lapses on the part of the authorities in not considering regularization during the subsistence of the Act, nevertheless, once the Act has been set aside, the state would not have proceeded to consider the regularizing. Further, it has been submitted that in the meantime, say identical. They are now saying that the 2017 Act does not exist. So we are not in.
2017 Act is very much there. 2011 Act does not exist.
2011 Act is not applicable to us. It pertains to venture educational institutions.
Sir, here they are saying that their services can be regularized as per the Act of 2017, but not as per the cabinet memorandum.
No, that is not.
That is the case. That is the whole case.
True.
Their prayers were for 2017. We are ready to consider it under the 2017.
But the
But
direction is of.
Direction is to do it from sometime behind.
But that will push us,
Their prayers allowed, we would have,
if your lordship will kindly help,
situation would be different.
that contention itself will fall through if your lordship peruses the impugned judgment.
Yeah.
And the facts,
Therefore,
the whole basis on which the cabinet took a decision was that all identically placed people were already granted the benefit.
That consider, and simply we are just on the deflating on this point, this is of nuclear. The matter comes up on the configuration of the IA members, so and so that they have to control the delay of 610 days in filing the connected. Please notice that twenty-four, 6, 2024. No, sorry. On 24, 4, 2024. This court has made the observation that in the interlocutory application, no explanation, no satisfactory explanation is offered by the applicants for condoning the delay. And at the request of the learned counsel appearing for the applicant, further time was granted to file an additional affidavit. Pursuant to the same, an additional affidavit is filed on behalf of the applicants, wherein the reasons for delay, for causing delay in filing the writ appeal has been mentioned in detail. Stop. It is from the perusal of the affidavit, it can be, it is revealed that since the matter was considered by the committees constituted by the state government and thereafter by the department concerned, the delay has been caused. Stop. Learned concept of the applicant has further submitted that as a matter of fact, the respondent in the writ petition has claimed provincialization of their services as per the Assam. Full name of the act is
Assam Education within bracket provincialization of services of teachers and reorganization of educational institutions bracket close Act 2017.
2017. However, the learned single judge has granted a relief to the respondents of regularization from the period from the which under the cabinet decision took taken in the year 2016 to stop. It is contended by the non-concept for the appellant that the stand of the state is that their services can be regularized as per the Act of 2017, but certainly not as per the cabinet decision taken in the year 2016. Stop. It's submitted that if the order passed by the learned single judge is implemented, then it may have huge ramifications in those cases where the regularization, where the provincialization process has already been completed. Stop. Learned concept of the applicant has therefore said that in view of the above submissions, the delay in filing the the IA may be allowed and delay in filing the connected rate appeal be condoned. Stop. Then consider appealing for the respondent as vehemently opposed the application and has argued that even in the additional affidavit also, no satisfactory explanation for condoning the delay is offered. To stop, it is further submitted that in the similar circumstances, when a division bench of this court has condoned the delay condoned the delay in filing the writ appeal on behalf of the state, the Honorable Supreme Court has reversed that judgment in civil appeal number dash 2024 arising out of SLP in bracket C number 9852/2023 decided on February 2024, while observing that when the delay has not been satisfactorily explained, the same can't be condoned. Stop. Having heard the learned concept of the parties and after taking into consideration and after carefully going through the additional affidavit file in support of the IA and also taking into consideration the fact that the prayer in the writ petition the respondent in the writ petition has made a specific prayer for regularizing their services as per the Act of 2017. However, the learned single judge has ordered for provincialization of the services, regularization, provincialization of the services of the respondent pursuant to a cabinet decision taken in the year 2016, and also taking into consideration the fact that it may have huge ramifications in the cases where the provincialization process has already been completed. We deem it appropriate to condone the delay filing the connected appeal. Hence, the IA is allowed. The delay in filing the connected appeal is condoned. Registry is directed to register the connected appeal cases for admission after 2 weeks.
Item 27.
Seven and 8, 9 has not been.
This matter, Millards, as per the last office note, the AD card has not been received, neither have the answer of notices come back, Millards. After I've seen the office note, Millards, I inquired with the desk pass section, Millards. The tracking reports, Millards, of India Post, I have them with me, Millards. The service has in fact been completed, Millards.
You submitted before the registry will do that after a week.
Very well.
For admission, item 28.
Non-present.
29.
Lordship, 28.
Yes.
Lordship, item number 28.
Yes.
Lordship, my senior.
28.
Yes, Lordship.
We have already adjourned it.
Lordship.
What do you want?
Adjournment, Lordship. This,
We have already adjourned.
Lordship.
Acha, on the request, on the request of financial after 2 weeks.
Lordship, it can be Thursday, 6.
2 weeks. 2 weeks adjourned at your request, yes.
Yes, Lordship.
Item number 29, ma'am.
Item number
29.
29.
Right.
Yes.
My lord, here, my lord, the grievance of the appellant, my lord, herein is regard to the marks allotted in the consolidated statement in violation of the office memorandum, my lord. My lord, I take your lordship to, for a second, for the consolidated statement at page 71, my lord.
Madam, both of you and the respondent secured equal marks.
My lord,
And the learned single judge
Yes.
applying this formula
yes, my lord.
that the date of birth, the person looking to the date of birth of the respondent has granted the relief. What's wrong in that?
My lord, I mean, with regard to the allotment of marks, my lord,
Yeah.
in the column with regard to leadership skills, my lord, at page, my lord, or
Column?
in page 71, my lord,
71.
one. In, of my 71.
Yes,
This is the consolidated statement of marks, my lord.
yes.
I take your lordship, for example, page 71, leadership skills column, my lord, in the extreme,
Page 71.
71, my
Yes, yes.
leadership skills. My lord could see the second name, that is the appellant, Pronouncement Deka.
Yeah.
He secured 4 marks and
2 marks in
leadership skills, leadership
Okay,
skills.
okay.
And the private respondent, my lord, the Satyajit Bora, the serial number 4, he also secured 4 marks, my lord.
Fine.
My lord, I take your lordship for a second for to OM, my lord, office memorandum, my lord. At page, the next page, at page 72.
Yes.
My lord, with regard to the OM, my lord.
Yeah.
Really, my lord, there are 2 OMs, office memorandum issued, my lord. This is the first OM, Annexa 7, my lord, it is page 72. Here, my lord, in leadership skills, while regarding to the allotment of marks, my lord, it is stated the results of HSLC, that is high secondary or HM examination in one case of high school, high madrasa, and HS second year final examiner in case of high secondary school. So, my lord, here in this Annexa 7, one OM was issued. The directive was not clear. So, the government has issued another OM at Annexa 10, my lord. I take your lordship to page 80. 2 OMs were there, my lord. Page 80.
Yes,
May I read again, my lord, the leadership skills column.
yes.
Results of HSLC, AHM examination in case of graduate teacher and HS final examination in case of postgraduate teacher in the school where he is a teacher, my lord. In results of preceding year of selection, right-hand corner, the allotment of marks were given, my lord. Up to 60% pass, 1 mark, 61 to 72, 71 to 83, and above 84. Here is the case of the case of the respondent is that respondent is a demonstrator. So respondent is a graduate teacher. So with regard to the respondent, my lord, being a graduate teacher, his marks would be considered with regard to HSLC marks, my lord. Here, my lord, the respondent was granted marks on the basis that he has secured 80% above 4 marks, my lord. 4 marks. Whereas the respondent, my lord, I take your lordship, the admitted part is that, my lord, the respondent has secured up to 60% pass in the school, my lord. It is 1 mark. The honorable single judge, my lord, while considering the plea, admitted that the school has secured 60% marks, that is 1 mark. But the honorable single judge has gone to the extent that since demonstrator teaches the students of high secondary school, so though demonstrator is considered as a graduate teachers, but with regard to allotment of marks, 4 marks will be considered that is equivalent to postgraduate teacher, my lord. That is in violation of the OM, my lord, because the OM says that, my lord, because while 3 marks were granted more.
Issue notice returnable 2 weeks.
My lord, the caveator is there.
Cavator, who is cavator? You are cavator. For-
Already joined the constituency order.
That's right, but you have to file counter to the. You notice, Mr. So and so put an appearance on, you are appearing, Mr. Majumdar?
My lord, I leave it to the department. Department of School Education.
So all the respondents.
Other
are
respondents.
My
Yes,
lord.
Mr. Majumdar is appearing on behalf of so and so.
my lord, I have 1 to 4, my lord.
Is appearing as cavator on behalf of the private respondents, and this is therefore complete. They may file their, the concept for the respective respondents may file their counter to the writ appeal by the next date of hearing, list after 3 weeks. Date there.
My lord, the outcome of the writ appeal said, my lord, because
That is innocuous order.
my
It
lord,
will remain.
my lord.
If we have issued the notice, then I think.
21.
Obliged, my lord.
Item 30.
May I please the lordships? My lord, the issue involved in the instant petition is, my lord, use of the agricultural land, my lord, for commercial purpose without reclassification of the same, my lord.
Now,
Without reclassification of the same, because the concern rules, my lord.
reclassification of the same, what do you mean by reclassification of the?
My
same?
lord, when there is agricultural land, that can be used for any other purpose other than the agriculture, when it has been, it is reclassified, my lord.
So,
So in the instant case, my lord, a particular plot of land that has not been reclassified, the proposal have been sent. And this particular rule provides for bars on the agricultural land for use for the purpose, any other purpose other than the agricultural activities, my lord. And here, my lord, there is a report of the circle officer that the proposal have already been sent, my lord, but it has not been reclassified. But the response number 7 with the aid of the respondent number 8, they have started, my lord, construction of some building over the agricultural land.
still it is not declassified from the agriculture.
Yes, my lord, it has not been reclassified.
Then
But they have constructed, my lord.
they
They have
constructed, file a civil suit for that.
no, my lord, because my lord,
If they are constructing something illegal.
yes,
file
my
a
lord.
civil suit.
My lord, the
Notice,
issue,
PIL petition.
my lord, issue is that by, my lord, the local inhabitants of the locality, my lord, they approach the petitioner organization because, my lord, now they have started construction over that plot of land. Gradually, my lord, they will acquire, because the neighboring land, my lord, those also will become unfit for agricultural purpose. Once they start,
Sir, it is owned by them.
yes, my lord.
So even though if they are doing anything in their agriculture land, which may not able to produce the crops,
Yes,
that is for them to consider.
my
Who
lord,
are you to ask them,
My
your
lord,
private land, you can't do this.
the petitioner is a pioneer organization, my lord.
Whatever pioneer organization is, suppose if you are having a plot
Yes, my lord.
in, or you are having a piece of land in some village,
Yes, my lord.
and if you are not going to, not using that for agriculture purposes,
Yes, my lord.
how anybody can force can know you use it for agriculture purpose?
My lord, that is in
That
clear
is your
violation.
land. You may, yes, certainly you can't have any other activities such as industrial, etc. No doubt. That
Yes, my
would
lord.
be illegal.
It is in clear violation of the laws, my lord. And there is a report of the agricultural department also, my lord.
And who are the aggrieved person?
Agri person is the persons, my lord, who have lands in the neighboring plots, my lord.
So how they have not been able to approach this court?
Because they approach the petitioner organization.
Who are you to approach them?
Yes, my lord.
How they are unable to approach this court?
My lord, because they approached us, so we thought that,
They
my lord.
approached us,
Yes, my
many
lord.
people may approach us, but the High Court rule specifically says that you have to specify that how those persons are not able to approach this court.
Because they are poor farmers, my
They are
lord.
poor farmers, from where and where they have authorized you?
My lord, in my petition, I have stated that, my lord, the local inhabitants of those or the local,
For that, sir,
my lord, to that effect, I can file an authorization or additional affidavit, my lord. In paragraph 8, my lord, I have stated, my lord.
authorization will do, sir.
Because, my lord, we have filed several representations before the respondent authorities and, my lord, on their behalf, because, and those representations also, we have enclosed with the petition, my lord. Already we have approached the respondent authorities, my lord. Page 235, my lord.
The High Court rule says specifically, a specific government in para number 3
Yes, ma'am.
of the writ petition specify the class of persons who benefit the petition has been filed and how such persons are incapable of assessing the court themselves. How they are incapable.
Because, my lord, they are poor farmers. And, my lord,
PIL petition is filed by the petitioners. Without specifying that the same is filed.
my lord, I may be
for
allowed
the
to
class
file an
of
additional
persons who
affidavit,
are
my lord.
whose benefit of the petition has been filed and as to how such persons are incapable of assessing the court themselves as required under Rule 10(4) of Guwahati High Court in bracket public interest litigation bracket close rules 2011. Yes, now what do you want?
My lord, I may be allowed to file an additional affidavit, my
And
lord.
it concerns the petitioner raise some time to satisfy the court on the said aspect. List of 6 weeks.
Obliged, my lord.
Item 34. Item 34.
Filed by the petitioner in person, can I edit? My lord, practicing advocate, on the last occasion also she did not appear.
Let us see, we'll wait for that.
My
Item 35.
May it please the Lordship. Lordship, in this case, I'm praying for some more accommodation because the government has already taken some decision and the final decision is yet
Yes,
to be.
yeah, where is that decision?
Lordship, like, it has not been finalized as yet.
That was the same statement on 17/5/2024.
Yes, Your Lordship.
That the state government is coming with coming up with the policy which can remedy the grievance. Where is that?
Lordship.
So what?
I'm praying for some more time, like at least till the end of September, that some final decision will be taken because with regard to work charge, already some decisions have been taken, but with regard to contingency, some more time is needed.
The state of Nagaland is very slow in taking decisions.
Lordship, since it involves a huge number of thousands of cases.
Then reject it or grant it.
Another last opportunity may be given.
Last opportunity is granted to the learned additional Advocate General of State of Nagaland to inform this court about the decision of the state government for grievances, for redressal of the grievances of the respondent petitioners. How much time?
Lordship, the decision as per my instruction will come up after the end of September only.
After that?
By the end of September.
Why? End of September,
Yes, Your Lordship.
but how it's so long time?
They're still collecting some reports.
Stop 8 months.
Deeply obliged.
Item 36.
May I please your lordship? Lordship, in this case, we will file a reply to the counter filed by respondent number 1 within the course of the day, lordship.
What affidavit you are filing?
Lordship,
What affidavit now you are filing?
reply to the counter, lordship.
Counter, what's their reply? What was their reply?
Affidavit in reply.
What is what they have contained in that affidavit?
Actually, lordship, my senior is also out of session. I'm not much aware. I'm sorry, lordship.
You have gone through before appearing before this court, you should have gone through the brief. At the request of the concept of the. This stuff for 2 weeks.
Deeply obliged.
37.
May I pick up? And in this case, there was a delay and the delay was condoned today. It has come up for admission. And this appeal is by the state manner against the judgment passed by the one single judge, whereby it has been directed that the respondent petitioners who were appointed as supervisor, they were working as Anganwadi worker. They were initially appointed as a supervisor in 2016 on contractual basis, and subsequently when the financial conference came for substantive appointment, they were regularized from 16th of August 2021. Now, the honorable single judge has directed that they should be, this benefit of regulation should be given from the date of initial appointment on contractual basis. We are agreed by that, my lord. My lord, their whole foundation of their claim for regulation is a direction by the central government, which your lordship will find at page 48, man.
Just a minute.
Any? কোনো recruitment হয়নি না। Recruitment হচ্ছে payment করা। Yeah. বরাবর। It's not there. Nine.
They are now working as supervisor.
They are working. From 21 days. From 21, immediately after the financial conference was given.
But you had regular vacancies.
No, my lord, we did not. That is why, my lord, your lordship will kindly have a look at page 123. Financial approval for these posts came on 10th of August 2021 and 16th August we have regularized. Immediately thereafter. There is no gap. My lord, page 123, my lord. And this document was annexed along with an affidavit before the honorable signature itself, my lord.
Though they were granted, they were appointed on contractual basis in the year 2016.
16.
But
At that time, there was
no post.
no, my lord. And my lord, if your lordship goes to the initial circular of the government of India, it says in the existing vacancy, you have to do it, and also in future vacancy. Now, if the existing vacancy, there was no substantive post, but they were appointed on a contractual basis with a fixed pay. Subsequently, when the substantive vacancy arose with the concurrence of the financial department, my lord, in 2021.
Yes.
Please. What happened? The central government took a policy decision in 95 to keep reserve 25%
For the Anganwadi workers.
post, 25% post for Anganwadi workers. While reservation, my lord, how the authority will arrive or calculate the percentage of reservation? How the authority
Percentage.
percentage. But I'll straightway rely a judgment of this honorable apex court, my lord. Constitution by judgment,
Citation. That's like.
1995, 2 SCC 755. Paragraph 6, your lordship kindly turn paragraph 6. Paragraph 6, your lordship.
Yes. Paragraph
6.
Yeah.
751. The expression post and vacancy often used in the executive instruction provided the reservation are rather problematic. The word post means an opportunity, appointment, job, office, or employment. A position to which a person is appointed. Vacancy means an unoccupied post or office. The plain meaning of the two expressions makes it clear that there must be a post in existence to enable the vacancy to occur. The cadre strength is always measured by the number of posts comprising the cadre. The right to be considered for appointment can be claimed in respect of a post in a cadre. Last line, 2 line is very important here. As a consequence, the percentage of reservation has to be worked out in relation to the number of posts which form the cadre strength. The concept of vacancy has no relevance in operating the percentage of. Now, what they did, my lord, when they filled up, they initiated the process to fill up 25 reserve posts of supervisor. And they followed the procedure of written test, oral. Thereafter, what they did, by issuing an engagement order, my lord, in designation. Your lordship has a look on that part, the order, my lord. Page 118.
Yeah, then we'll admit it.
My lord,
Matter of
the
request
my
hearing.
contention is that always reservation against the vacancy, a book post. And that can.
But that is RK Sabral, that is in the context of reservation for SC, ST.
No, my lord, reservation is not said that only for ST. This is a general general.
Mr. Kotak, the only thing the court would like to see here is that whether regular vacancies were available at that
My lord,
time.
that's the difficulty. Government has not said that how much cadre strength.
We'll find
Cadre strength depend on the basis of cadre strength, our vacancy will be filled up. My lord, when you start the procedure of filling a post against a reserve quota, it must relate back to the cadre strength. That is the law laid down by the apex court, my lord. What I am on.
Having heard the non-consent of the parties, we are of the view that matter requires consideration. Hence, admit no need to issue notice. And the parties have already represented. In the meantime, the direction given by the learned single judge of paying the dues of the monthly salaries, treating the appointment of the petition respondents on the post of supervisor from 6/2/2016 and to release the payment of so and so and to fix their seniority, including scale of pay as per the said direction is hereby state. This
We will get the current.
however, the state, however, is made clear that the respondents, private respondents here will get the regular salaries from the date when their services have been regularized. When their services have been, when they have been appointed as supervisor on regular basis, that is on
16th August 2021.
16th August 16/8/2021.
Develop.
This for hearing in due course.
Item 39.
My lord, I'm appearing on behalf of customer number 138 petitioner.
Responding number?
Number 138 petitioner, my lord, as per lordship direction on 24/3/2024. I appeared before the authorities on 11/7 as per regular direction 8. I appeared 11. I appeared before the government and also DMC is also as per their instruction. And the result will be whatever is
Lordship, sincere apology in this matter, Lordship, though I was asked to get the instruction, but the authority inadvertently, Lordship, has placed the instruction and giving it to your Lordship, Lordship. I'm extremely sorry for this, Lordship. Lordship, it says that, Lordship, he is, Lordship, this. I'm extremely sorry, Lordship, for this, Lordship. I have already informed him, Lordship. Sincere apologies.
And it appears that our suspicions were correct. It is, and
Lordship,
from what I gather, it's a infection in the ear, which is purely temporary in nature, and it is curable. That is what based on this is, my friend has given me a copy of this instruction.
Para 2, Lordship.
In the second para,
Very soon he's going to, very soon. At page 6, Lordship.
Get the proper order.
Yes.
Not in this manner.
Yes,
Okay, and then concept appearing for the respondent number 1 has submitted that as per the direction given by this court on 24/6/2024. The respondent number 1 has already appeared before the competent authority for the purpose of getting permanent disability certificate. And the said competent authority has examined the appellant. And it counsel appearing for the
Health and Family Welfare Department.
Health and Family Welfare Department has submitted that the report of the medical examination of the respondent number 1 in respect of in respect of degree of permanent disability would be will be filed within a period of 1 week.
Lordship, can it be, Lordship, 2 weeks, Lordship?
Why?
Because, Lordship, the person concerned is going to retire on 31st, Lordship. So, Lordship, I'll get a detailed, Lordship. These are all technical, Lordship. I'll have to get.
Up to 2 weeks, list on after 2 weeks, list of after 2 weeks, list on so and so did be interim order
9 tenths.
dated interim order dated 9/10. Sorry. Interim order dated 24/6/2024. 24/6/2024 shall remain in currency till next week.
Can it be on 14th August?
Let the report come
14 more.
and
14 more available.
supply the copy of that report to counsel for the respondent.
Yes.
14th, I am not.
Along with that affidavit, what you are.
Yes.
Furnish that affidavit.
12th.
Yes,
13.
12.
Okay.
Highly obliged.
Item 40.
May please, your lordship, as per lordship's direction, I have to file reply, lordship. So lordship, I pray for 2 weeks time to file reply.
You are for
I am for respondent 1 and 2, Lordship.
respondent number 1. Becomes council appearing for the respondent number 1 and 2, raise some more time to file counter to the writ petition, time period for his writ appeal, time period for his granted. List after 2 weeks, interim order dated 21/6/2024 shall remain in currency till next date.
41.
My lord, despite the affidavit has been filed by the Chief Secretary of Assam, my lord, there is no any definite period given regarding the release of the amount.
As regard the budgeted amount, Lordship, I kindly take up our affidavit, my lord, paragraph 5.
Affidavit,
Affidavit filed by the person to the Lordship's order
when you have filed this affidavit,
on 22nd of July, my lord. It is on record, my lord. 22nd of July.
not available.
It is on record. My lord.
Not available on record.
22nd.
So original file is with us.
No.
Let us look.
One of some of the assembly, my lord. My latest instruction, my lord, is that the budgeted amount of 9 crore, they already it is approved, and the financial section they are giving.
9 crore. You are- From last 4 months, you are saying 9 crore, 9 crore. What is this?
For a
44 crores in the month of December 2023.
My lord, for a moment, my lord, let me submit, my lord. But the financial sanction they are giving it today. They are moving the finance department today itself, my
How
lord,
much money?
for 9 crore rupees, because it is
Again, 9 crore.
it is the budgeted amount, my lord. My lord, kindly on my affidavit we have stated, my lord. My lord, the budget, the demand of 52 crore rupees has come in the month of May, in the midway, my lord. Already, my lord, the budgeted amount is fixed at 9 crore, and my lord, in paragraph 7, my lord,
Whatever it may be, you have to pay that money.
True, my lord. my lord, what
Since
they
it
have,
is not it's victim compensation, sir.
correct, my lord.
We
My lord,
can't wait for that.
but they have what they have stated in the affidavit.
We'll ask you. Once Mr. Dinath has submitted it, he has already filed an affidavit on behalf of
On behalf of the chief secretary, my lord.
Chief Secretary.
Yes, my lord.
On behalf of the Chief Secretary, the same is not available on record. Office to place the same on record. Office to check and place the same on record. List on 5th of August. 5th of August.
Lordship.
Now minded. Please release the money.
By that,
That's all.
but the budgeted amount will be released to that, then, my lord, by that.
Budgeted amount, we are not concerned with that.
My lord,
Why it was not included in the budget? Who is responsible for that?
my lord, in the month of May, it came.
No, who is responsible for that?
That's an incorrect statement, Your Lordship. 44 crores demand was raised in the month of December
Yes.
23.
My lord, I can't go beyond.
30th of December 2023, we had raised a demand for 44 crores. Naturally, it has now increased to 52 crores till May 2020.
My lord, if Lordship allows me, I'll just read paragraph 7, two sentence, my lord, 2 sentence of the paragraph. My lord,
We'll see to it.
whatever
Fifth
we
of
have stated in the
August,
affidavit, I can go with that, my lord. I can't go beyond the
Mr. Nath, a
Lordship.
simple question has been put.
My lord.
These are statutory allotments.
True, my lord.
There is no discretionary power on any authority to tinker with it. You are saying the money could not be released because it was not incorporated in the budget. So who is responsible for this?
My lord,
That's what we are asking.
My lord, that is what my lord, I'm indicating, that the budgeted amount is really going to be released very shortly. And my lord, the-
Budgeted amount, again, budgeted amount,
for
what,
the- for the-
what
for the-
my lords is asking, when the demand is of 40 crores or how you make a provision regarding 9 crores only?
my lord, the additional
Who
for
is
the,
responsible for that?
for the additional budget, additional amount through the supplementary demand, they will take care of, my lord.
When-
That we have
Now
indicated in the
they are saying
affidavit.
the amount is raised up to 252
No,
crores.
52 crores.
So what about that?
Lord, that we have indicated in the affidavit. Lordship, I'll place it.
Fifth, again come with this explanation when you are going to release this additional demand or when you are making a provision for this demand in the budget.
But Lord, they said that
Mr. Dinath,
once
they said again,
So they keep playing this blame game
These
with
are
us, if I may just point out.
no, there is
What
no
they have
question
done
of any
is,
blame game, my
when
lord.
we raised the demand of 44 crores, they gave us a telephonic call and I've placed that on record. That we can only provide 9 crores. You please redo your entire budget and submit a proposal for 9 crores. We do that. Then they tell us, no, you break it up into 2 parts, make it 4.5, 4.5. And Lordship, in all this entire process, the executive chairman of the SALSA is also involved. I've put on record the notings that he's approving that, okay, we are sending 4.5, 4.5. We did that also. And now they're saying that we have not furnished the utilization certificate of 23-24. I draw my friend's attention to page 141, where we have already submitted utilization certificate a long time back, Your Lordship. The demand of 44 crores was raised on 30th of December 2023. I do not know where this thing comes from.
still you are able to defend them.
But-
Are you sure?
Well, the question is not depending, my lord. I'm just indicating what is stated in the affidavit as regard the additional amount. But once they said that once the budgeted amount of rupees 9 crore is exhausted, the government in the home and political department shall endeavor to provide the additional budget through supplementary demand. That is what the instruction is, and that is what we have. placed before your
Section
lordship.
says, what do you mean by once this 9 crore rupees is
It is
utilized?
it is exhausted. Then-
Exhausted, so what do you mean by exhausted? It
Matlab-
is when
matlab-
the demand is 44 crore or 50 crore,
Pending.
certainly it is already exhausted.
मतलब
This
they
is the question of exhaustion.
मतलब
Spend थोड़ी करना है उनको distribute ही करना है.
distribute करना है. That true, मतलब true.
That is the order of the courts.
But I'll indicate मतलब.
Fifth को you come with the definite proposal or otherwise then we'll be forced to call your some.
Matlab I'll
No,
I'll-
only
I'll-
one line is important, paragraph 7, where they have said that they have to submit supplementary demand proposal if there is need to additional fund. But this
Mr. Tamare, the affidavit is
Right.
not on record. What are you reading?
from the affidavit.
No, blind.
Timing item 34.
Even in second, even on second call, list of rate.
For hearing, item 43, 44.
Please, your lordship. Your lordship, my senior's appearance is required in this matter, and suddenly he has to leave for Delhi yesterday. So I request your lordship's indulgence for today.
So you remain on the board.
Item number 46.
My lord, I have come to know that one order is passed by your lordship, my lord, in another case. So I need to examine that order, my lord.
What order we have passed?
My lord, in respect of some LP school teachers, they have claimed for some benefit, and that is.
Graduate, if a person has a graduate degree but was entered into service as an undergraduate teacher, would he be entitled to the graduate scale of pay?
Validity of that rule?
My lord, yes. That was, my lord, decided by lordships in the case of LP school teachers, the lower primary school teachers. These appellants are upper primary school teachers whose read petition has been dismissed because they sought their graduate scale of pay. Read petition was dismissed, now they are in appeal.
So I need to examine that, my lord. In our case. Even.
Acha, Mr. Majumdar, they are in the category of tutor under the 2000.
No, madam, they are
No.
teachers who are recruited as teachers
Okay.
into the schools. They teach in the upper primary classes from class 6 to 8.
Correct, but they did not have the graduation. They did not have
They
the.
were not required to have graduation to come
Entry
into the service.
qualification is higher secondary.
Higher secondary. They say that they have acquired graduation and therefore.
Actually, it's correct, you know.
Incorrect question.
ना ना आपने ग्रेजुएशन वहाँ पे बात कर लिया एमसीक्यू मतलब the entry level qualification मतलब both.
You are seeking time to.
Yes,
or otherwise, if you are ready.
I will examine my lord.
we are also-
I will examine that after 1 week.
Remain on the board fast forward.
What is it? Remain on the board. As you can listen, you have.